First off, copyright is actually mentioned and protected in the U.S. Constitution. It goes back that far. The founding fathers actually realized that, copyright was a good thing because what they said was promote the progress of science and useful arts by giving creators exclusive rights to their works for a limited period of time. That's been codified in the federal law and the U.S. Code, which is the listing of all the laws in the federal laws in the United States. It's usually called U.S. Code Annotated. It's in Title 17. And it provides for methods of copyright, what your rights are, how to do it, etc. It's not as complicated as you might think it is. In fact, it's not complicated at all. So if you file a copyright or you copyright your product, what do you get? Well, you get a number of things. You get the exclusive right to reproduce the work in copies or records, CDs, digital. You get the exclusive right to prepare derivative works from it. Like, it seems like every movie now has another one and another one, like the Harry Potter series like that. So that protects you down the line. So you can't have a successful product and then someone steals it and off they go with the sequel. You get the exclusive right to distribute, sell it, perform the work publicly, display the work in the case of a play or art, painting, something like that, and to perform the work publicly. And that's usually for people who are doing music. However, there are some entertainment people who read, do essays. Like in the old days, Mark Twain used to travel around the United States giving talks, and that would be protected. So who claims the copyright? Well, of course, the creator of the product, unless you're working for someone else. In the old days, I think they called it Tin Pan Alley. They used to come out with all sorts of songs, and they worked for the music company. So the music company owned the songs. And I think Motown was notorious for that. All the people who worked for them were employees, called employees for hire. So even though those people were fantastically creative and really were the ones who made the songs, they were owned by Berry Gordy and Motown. So, I'm not that any of you are working for someone, but if you ever did, that would be the circumstance. So you might want to think about that if you're getting yourself hired out. So what kind of works are protected? Well, we went into that somewhat. Literary works, and this is the Christian Writers Guild, so I imagine that's going to cover most everybody here who's not right. Musical works, dramatic works, pantomimes, choreograph, if anybody's into ballet, pictorial, graphic, sculptural, motion pictures, sound recordings, and architectural works. I was kind of surprised to see that. What's not protected? What is not protected is works that have not been fixed in a tangible form. And I think you can understand what that means. If you've got a great idea floating around your head, but you've just never gotten around to putting it down in some tangible form, or you have a tune in your head that you've never recorded, well, naturally, that's not going to be copyrighted because how would you ever prove that it occurred that? Also, titles, names, short phrases, slogans, not covered. Ideas, procedures, concepts, and then stuff that's information that's generally known to everyone. So anyway, when a work is created, that's it. You have a copyright. One guy, the fellow who turned me on to this, the guy who teaches at Tulane, said there's something called like a poor man's copyright or something. You take your transcript, you take your book, whatever it is that you created, and you mail it to yourself and don't open it. So you've got the sealed envelope with the date, with your stuff in there. So should it ever arise, don't open it, you would be able to prove that at least from that time forward, that was yours. That shouldn't cost you too much money. For works produced after 1978, I guess that was an arbitrary cutoff date, and that would apply to all of us, I would hope. The copyright lasts from the author's life plus 70 years. That's a good long time, huh?
Maybe.
Mm-hmm. Yeah, and or if there's joint authorship, 70 years from the the last surviving author. You can sell a copyright if you want to. If someone wants to come buy it from you, you can sell it. And of course, they would have all the same rights that you just transferred. There's no such thing as an international copyright. That all depends upon the laws of each individual country. And if you follow the paper, there's a lot of problems now with foreign countries, especially China, that don't think anything of snatching up, music and pirating all sorts of things, movies and everything. So if you go through a publishing company and they pay you for it, you still maintain the copyright because you have produced the work, unless you sell it to them for whatever reason. If you sell it to them, of course, they have the right to market it, keep the money, and all that sort of thing. So you may want to think twice about that if you go through a publishing company. If you're self-published, of course, you don't have to worry about that at all.